Hello everyone, and good morning from Brazil. Good afternoon from Russia and from India, and Terrence, of course, a good night from China, but he's in the U.S. So good morning too. So we're organizing this week the BRICS plus ADR ESG Law Week, which has 6 panels. It's composed of 6 panels, and we're discussing the cutting edge topics about the BRICS plus countries, which are the BRICS is a group who is increasing. More members are coming, more partners are coming to the BRICS. So it's a topic which we must discuss. And first of all, I'd like to thank the Arbitration Channel for hosting this BRICS plus Law Week, and of course, Lauro Parente, the CEO of the channel, and Andrea Silva, and all the backstage team who is organizing here, Fernando, Rafael, and everyone. Thanks a lot for your hard work to put this together. So we have 4 really special guests here today, and very experienced arbitrators, because this panel at the end of the day is about arbitration in the BRICS plus countries. So we have my dear friend representing India here. We have actually the original BRIC, the BRIC without the S here in this panel. So we have Brazil, myself, India, China, and Russia. So Ajay Thomas is representing India, Yuri, Makhonin, and Tatiana. I'm not going to be able to pronounce your last name, Tatiana, but I'll try. Polevshchikova, representing Russia, based in Moscow, and Terrence Leow, of course, representing China. So to begin with, I'm gonna give you some room for the initial remarks. So of course, this class I didn't skip, so we'll start with the lady in the panel. Tatiana, please, if you could introduce yourself and make your initial remarks. Thanks for being here.
Thank you, Daniel. And first of all, I would like to sincerely thank you for having us here today. It's very important to establish and continue developing this dialogue in relation to BRICS plus dispute resolution. There is a lot of things, a lot of innovations going on, and it's not always the case that we have a platform to come together and discuss and share our experiences. So thank you for that. Thank you for bridging the different worlds. So I specialize in international arbitration, and I work as counsel at DGP based in Moscow. My particular focus is on Southeast Asian countries and ASEAN. I gained initial arbitration experience in Hong Kong with the ICC International Court of Arbitration and HKIC, and subsequently worked at the Asian International Arbitration Center in Malaysia, where I was doing case management and also developing a number of regional and international projects, including also regional cooperation, projects related to regional cooperation within ASEAN, and certain projects between Malaysia and One Belt, One Road countries. Since 2021, I'm back to legal practice and remain connected to Southeast Asia, including, for instance, through my commitments with the Inter-Pacific Bar Association, Malaysian Institute of Arbitrators, and HK45. So taking into account this background, today I will be sharing my thoughts in relation to further expansion of cooperation between BRICS and a number of ASEAN countries, with the focus on the ADR sector.
Absolutely perfect, Tatiana. You bring an extensive experience in international arbitration, and that's what we want here in this panel today. Of course, all of you do bring that experience. But now with following the alphabetical order, please, Ajay, thanks for joining us from my dear India. The floor is yours. Your microphone is muted, Ajay, please.
Ladies and gentlemen, good afternoon, good morning, good evening to all of you around the world. My name is Ajay Thomas. At the very outset, I'd like to thank Daniel and the Arbitration Channel for this very kind invitation to be part of this very illustrious discussion on arbitrations in the BRICS plus countries. Now, to briefly introduce myself, I'm based in New Delhi. I sit as an arbitrator. I'm also an ADR consultant and also a law teacher. I've spent about 24 years in the law, essentially looking at different facets of the law, working as an arbitration administrator, as an arbitration counsel, as an arbitrator, and also as a law teacher. But I must say that I've spent the large bulk of my years running, establishing, and managing arbitration institutions, starting with the SIAC in Singapore, the LCIA. I set up the India operations. I've also worked with the Singapore Chamber of Maritime Arbitration. And my most recent institutional engagement was in Oman with the Oman Center for International Commercial Arbitration. So right now, I am back to being an independent arbitrator, and I do all kinds of matters, domestic arbitrations as well as international arbitrations. So looking forward to the intellectual stimulus of this exciting panel. Thank you once again for having me.
Thank you, AJ. You really bring an extensive history in arbitration and in managing arbitration institutions, which I share with you here. So, my dear Terrence, good morning in New York. Please, the floor is yours. And China is also very relevant for Brazil. But China is the first commercial partner in Brazil, so it's the biggest GDP in the BRICS countries. So please, Terrence, introduce yourselves.
Hi everyone, thank you Daniel for having me today. It's a pleasure to join the Arbitration Channel today and by sharing some of the thoughts and development in China. So myself, I'm dual qualified back in UK and China. So I'm a full-time lawyer and also arbitrator as well. So my main profession is to assist for numerous arbitration institutions in China, mainly like in Shanghai, and Guangdong, in Zhuhai, and Hainan. I'm also an arbitrator in Brazil as well, thanks to Daniel for the introductions. So my main job is to help a lot of countries to enforce the arbitral awards in China. This is what I specialize in. So in terms of, I also law teacher as well in Guangzhou. I teach a few students about international arbitrations. And it's quite interesting how China has developed in terms of ADR. As you might know, there's a new development in Hong Kong. So Hong Kong is now the latest, the world mediation center, which play a quite pivotal role in ADR sector. I'm eager to share some of the thoughts and development in China to all of you today. Thank you.
Thanks, Terrence. And now, last but not least, Yuri Makhonin, please. The floor is yours. You're muted, Yuri, please.
Good afternoon to everyone, or good morning. Daniel, thank you very much for the invitation and for the opportunity to be included in the panel of so esteemed speakers today. And I hope that the audience will like and will enjoy our panel and our discussion. I'm working with the same firm together with Tatiana, and I'm based in Moscow. I'm a partner, I will say, with one of the leading and probably the leading law firm in Russia, focusing on international arbitration. We have a very big team here. We have more than 45 lawyers focusing both on international arbitration and on local Russian dispute resolution or litigation. I practiced for more than 20 years in Russia, and I'm also an arbitrator, and I'm included in the panel of several Russian local domestic arbitration institutions. And I practice and do both international arbitration and Russian litigation, and I focus on so many types of disputes, really. And I think I've handled more than 100, several hundred disputes in both Russian domestic courts and international arbitrations. And I'll be very happy to speak about the legal framework for arbitration in Russia, about the challenges which Russian arbitration is facing right now, and to speak about the Russian arbitration in general.
Thank you, Yuri. Spasibo. Russia is also a very interesting jurisdiction, and so I had the opportunity to go to Moscow, and it's really an amazing place, an amazing city, and arbitration sometimes, especially for like the Brazilian audience in Russia, and also of course in China and India, they are a little unknown. It's still unknown, and we're talking about the BRICS here, so this cooperation is necessary for us to move forward. So to begin with, I'm gonna start with a general question, and please feel free to jump in about each country. And Tatiana, if you want to answer this question about talking about Russia, complementing what Yuri says, or about the Southeast countries, feel free. The floor is all yours here. So, when we talk about arbitration here, we always talk, especially in the international arena, we talk about if a country is arbitration friendly or not. So that's necessary. So if you go to the UNCITRAL website, you check the list of which countries have a UNCITRAL-based law. If you go to the New York Convention site, you go check their status, so you see which of 172 countries actually have ratified the New York Convention. So this, of course, shows the harmonization of the international scenario here. So I can tell you guys that Brazil, for example, is considered an arbitration-friendly country because we have a good law from 1996. Our state courts, they actually protect the arbitration, like the competence principle, and they don't modify awards or annul awards or set aside awards for nothing, just for the formal cause established in the New York Convention, mainly because our law actually basically copy and paste those grounds from the Article 5. So Brazil, for example, we consider, of course, we have our flaws. We need to improve some features like every country, but we are moving forward to the best practices here as always. So please, do you consider your country arbitration friendly, and why so? So let me start with AJ to talk about India. Please, AJ. You're muted, AJ, please. Don't forget the microphone.
Thank you, Daniel.
AJ, one important feature here, one comparison, is that Brazil is very similar, like between quotation marks, to India. Your law, your Arbitration Act is also from 96, and you had a huge change and modification in 2015, just like us, but you had another one in 2019 that we didn't have. So please enlighten us about India.
Thank you, Daniel. I think there are indeed a lot of similarities between, India and Brazil, and for that matter, with the statutes of most other countries around the world. And I think to a certain extent, credit for that should go to UNCITRAL for its tremendous stellar work in the harmonization of international trade laws. And as you rightly mentioned, the New York Convention, as well as the model law on international commercial arbitration, have been two instruments which have played a very, very important role in ensuring there's a certain element of similarity between arbitration regimes in different parts of the world. Now, when you're talking about the Indian arbitration scenario or the ecosystem being arbitration friendly, I think any discussion on this aspect of the arbitration ecosystem in India should start off with a little bit of historical perspective. There was a time in India, not too many years ago, probably about 40, 45 years ago, when the Supreme Court of India, in a leading decision, described arbitration in India as a process which made lawyers laugh and legal philosophers weep. So this is the historical concept or the historical background in which one must see the current reforms which have happened in the arbitration ecosystem in India. And what has happened in the last 2 decades, I must say, has been very transformational. The last few decades have seen a gradual but perceivable shift in the popularity of arbitration as a dispute resolution method. In the good old days, it was court litigation for everything. But now we see the popularity of arbitration has increased. And what this has done is that it has also awakened the stakeholders in the arbitration system to awaken to the potential that the system or the process of arbitration offers to parties and to the legal profession. And it's all these reforms and perspectives are very important in the Indian context because of one major factor. The mainstream public justice system that we have in India today has simply failed to cope with the huge pendency of cases. As of yesterday, there were in excess of 50 million cases pending in the various courts in India. And therefore, ladies and gentlemen, arbitration today is being increasingly pushed and promoted by not only the judiciary, but also by the government, and everybody else who has a stake in this whole dispute resolution system as a sort of panacea towards actually providing an effective and efficacious method of resolving disputes in India. So when you're looking at the judiciary, historically, courts in India have viewed arbitration with a little bit of suspicion. And the courts in India have always struggled between finding that right balance between intervention and support to the process. And but I must say that in the last decade or so, things have changed. There's been a course correction by the courts. Barring the odd aberrant decision, the courts in India, especially the Supreme Court and the High Courts, have been to a very large extent supportive of the process of arbitration. They have taken a very non-interventionist attitude towards the arbitration process. Live and let live appears to be the motto now. And I believe this is a correct approach. And this realization, there's also a realization which has come with in the judicial circles that one very effective way of reducing the huge backlog in the courts is by promoting arbitration and ADR. So, and what this has led to is that the courts themselves have established court-annexed arbitration centers in India. And these arbitration centers have done a tremendous job in not only trying to reduce the pendency of cases and reducing the backlog of cases in India, but it's also ushered in a new wave of institutionalization of arbitration in India. So I think this has played a very, very important role. There's a very important message which has been sent out that the courts are not against arbitration, the courts are for arbitration. Now, along with the judiciary and the courts, the other major stakeholder in this whole process of arbitration is the government. Now, I think the government also in recent years have realized that arbitration is the most preferred method for people wanting to invest in India. And arbitration is, and having an efficacious method of resolving disputes through arbitration and ADR is something which the government thinks will promote foreign direct investment in the country. And this is what has actually led to the reformation, the statutory reformation process, which Daniel alluded to earlier. We had an Amendment Act in 2015. We had another Amendment Act in 2019. We had another Amendment Act in 2021. And in October 2024, there was a draft bill to further amend the statute, to fix all the flaws which have come about in the workings of the Arbitration Act from 2015 until 2024. So I would like to believe that on the legislation front, the government has taken a very proactive stance in amending the law very proactively and at periodic intervals to fix a lot of the issues with arbitration in India. The third stakeholder, ladies and gentlemen, I would like to believe is the legal profession. Now, about a year ago, the legal profession in India came together and formed an arbitration bar. It's called the Arbitration Bar of India. And this Arbitration Bar of India has been established as a community of lawyers with the aim of promoting and propagating arbitration as a preferred means of dispute resolution. And one of the core missions of this Arbitration Bar of India is to impart best practices and train the next generation of lawyers in the field. Another stakeholder, ladies and gentlemen, are the regulators regulating the profession in India, which is the Bar Council of India. And on this, also there's been some good news qua the arbitration friendliness of India. The Bar Council of India in 2025 amended its rules for registration and regulation of foreign lawyers in India. So what it has effectively done is now, it has opened the doors to foreign law firms and lawyers establishing offices in India. Of course, there are regulations, there are detailed rules which have to be complied with. But what has happened, ladies and gentlemen, is that now you have a foreign investor investing in India having the freedom to have choice of counsel for his transactions and also for his international commercial arbitrations. So, which again, I think is a sign that India has slowly but surely transformed itself into a more arbitration-friendly jurisdiction. So if I were to sit down today and look at where we stand as a nation on an arbitration friendliness index, from an index of 1 to 10, I would like to believe that India is a 7.5.
That's a good rate. That's a good rate. If I compare to Brazil, we are at the same stage here. Like the courts, they actually sometimes in some hard cases they stay in between supporting or intervening in arbitration. But I can tell, for example, the rate of setting aside arbitration awards here in Brazil, partially or fully, is just like 15%. So of the setting aside motions that reach the judiciary, so the court, so it's very low. So I can tell you that the courts, they really support arbitration here in Brazil. But now, of course, let's go to my dear Russia. Please, Yuri, is Russia arbitration friendly? What's the status in Russia that you can tell by your practice here?
Well, thank you very much. This is a very good question for Russia these days, because I would say that Russia has been always blamed for being not sufficiently arbitration-friendly jurisdiction, where the risk of non-enforcement of arbitral awards remains higher. And I would say that until recently, there were a lot of cases when Russian courts have shown a willingness to enforce and recognize arbitral awards, because Russia is a party to the New York Convention, to the European Convention on International Commercial Arbitration, and so on and so forth. But we see right now certain trend of Russian courts and Russian legislation to prioritize national legislation, especially in cases involving sanctioned entities or disputes with so-called unfriendly states. Because I think there are certain, challenges for Russia to be an arbitration-friendly jurisdiction today. First of all, this is sanctions. because Russia is the most sanctioned country in the world. And this caused the Russian government to prepare and publish a list of unfriendly states. So these states impose or support unilateral sanctions against Russia and Russian companies. And this list of unfriendly states include European Union, United States, United Kingdom, Japan, Australia, Singapore. None of the BRICS countries are there. And the second, so this means that when there is a case involving with the seat of arbitration outside of Russia, when the seat is within one of these unfriendly states, then this cause difficulties in recognizing and enforcement those awards within the Russian Federation. And the second challenge is that the Russian courts have shown a special interest to issue anti-suit and anti-arbitration injunctions, effectively preventing parties from pursuing arbitration with seats in those unfriendly states. And we see a lot of disputes and where the Russian courts assert their exclusive jurisdiction, especially when those disputes are affected somehow by the sanctions or they involve sanctions entities. And I would say that those anti-suit and anti-arbitration proceedings in Russia are very widespread today. Those proceedings quite fast. And the special feature of those Russian anti-suit and anti-arbitration injunctions is the possibility for the Russian courts to issue a so-called cost order urging to comply with the injunction. So the Russian court may fix a certain sum in this order or design it as a daily penalty, which urges the other party to comply with anti-suit or anti-arbitration injunction. So therefore, it is very difficult to say whether the Russian arbitration, or whether Russian is arbitration friendly country right now.
Well, Yuri, in my experience, I had the opportunity to go to Russia last year twice, and I've seen that the Russians, they really discuss arbitration a lot. So it's in the society and it's being practiced, of course. And you have Russia has a similarity with Brazil that Russia signed but never ratified the Exceed Convention, for example, for investment arbitration, and Brazil never signed the Exceed Convention. So, if we talk about investment arbitration here, we are the same pattern. We follow the logic of the BIT contracts, and being a Brazilian, we are a friendly country, and I was glad to know that we don't even need visa to enter Russia, and of course Russians don't need visa to enter in Brazil. But you have a legal framework, and of course the arbitration is being practiced a lot. So, but of course sanctions are always a challenge in arbitration when it comes to arbitration. And so, Tatiana, please, if you want to talk about a little bit more about Russia or, of course, Southeast Asian countries, your specialties, please enlighten us here with your knowledge.
No, thank you, Daniel. I think Yuri made a great overview of everything, of the most recent updates. So I'll just continue with Southeast Asian countries. And just before I start, and in the interest of time, of course, I won't be covering all the Southeast Asian countries or each of the ASEAN countries, but those who are actually making the news these days, which is 2 or 3 countries. For the benefit of everyone, I just wanted to kind of provide a very quick overview of the principles or the main criteria we take into account when we discuss the arbitration friendliness of a particular jurisdiction. And when we do it, we usually rely on the Chartered Institute of Arbitrators 2015 London principles. And there are 10 principles we usually look at: modern international arbitration law, independent judiciary, legal expertise, education, right of representation, accessibility and safety, facilities, ethics, enforceability, and immunity. in addition to what we have already discussed, the arbitration, mainly the arbitration laws and regulations in a particular jurisdiction, there are more factors for us to consider. So speaking of the Southeast Asian countries, the arbitration laws are certainly there. And moving on to the discussion of particular countries, I would touch upon Malaysia, Indonesia, Vietnam, and Thailand. Indonesia joined BRICS officially as a full member on the 6th January 2025. Malaysia and Thailand joined BRICS as partner countries on 1st January 2025. Vietnam was invited to join BRICS as an observer, but hasn't yet confirmed that status. And what does the status of a BRICS partner actually entails, and how is it relevant to the discussion of the arbitration friendliness? So a partner state is actually a new category for integration of prospective members. The discussion about the country modality resulted from the mandate established during the Johannesburg Declaration discussion, and its creation was actually announced at the latest 16th BRICS Summit in October 2024. So partner countries have actually the ability to propose initiatives within BRICS, but they will not participate in the approval of documents on voting. Partners are generally invited to participate in the BRICS Chancellors and Leaders Summit. However, they can also present in other meetings if there is a consensus among the members. So how is it relevant to the discussion of the arbitration friendliness? This simply means the partner status that partner countries can be integrated in the dialogue on the establishment of the BRICS arbitration mechanism. According to the publicly available information, for instance, on 20th September 2024, a special working group of the Arbitration Center at the Russian Union of Industrialists and Entrepreneurs presented the BRICS Plus arbitration mechanism, and it was jointly developed by the Association of Lawyers of Russia and representatives of certain BRICS member states. So far, several basic documents have been drafted to regulate the activities of the future arbitration mechanism. First, agreement among arbitral institutions to establish a single consolidated arbitration mechanism. Second, BRICS Plus arbitration mechanism rules. And third, recommended arbitration clause for the referral of disputes under the BRICS Plus arbitration mechanism rules. So looking at all these three components through the lens of new potential members, for instance, Malaysia, Thailand, Vietnam, they certainly have rich and diverse experience to share. Both Malaysia and Thailand have their own arbitral institutions, Vietnam as well, local judiciary, and members of the legal community also have significant experience in arbitration. And arbitration legislation, as I mentioned, is also in place and is being periodically revised. And as an example here, I would like to provide recent amendments to the Arbitration Act 2005 of Malaysia. The Arbitration Act was revised last year in 2024. In addition to a number of procedural clarifications, such as appointment of arbitrators and multi-party arbitrations, a fundamental change was made. And I remember that amendment was proposed at the time when I was working in Malaysia, and it was under discussion for a number of years. This is an amendment related to the third-party funding. So Section 10 of the 2024 Act now introduces a new Chapter 2 in Part 3 of the 2005 Act. Basically, it introduces new provisions to regulate third-party funding. This act will provide that the common law rule against maintenance and champerty shall cease to apply, meaning that future, but not past, third-party funding agreements shall not be treated as being contrary to public policy on the grounds of maintenance and champerty. In addition, digital and electronic signatures on arbitral awards are now being permitted. This is also a very important change because I remember, especially in the times of the pandemic, it was a hassle to sign and circulate awards in international arbitration cases where arbitrators are each of the arbitrators is located in a different country. So this also serves to streamline the arbitral process towards greater efficiency, especially in the context of international disputes. Importantly, The Asian International Arbitration Center, which is located in Malaysia, is undergoing a number of important structural changes. For instance, a long-awaited Court of Arbitration under the umbrella of the AIC is currently being established. And the center itself was established back in 1978. So it also possesses great experience in terms of administering arbitration, including international cases. So it can be the case that, for instance, the AIC or Malaysian practitioners can actually contribute to the dialogue on the establishment of the BRICS Plus mechanism. Lastly, speaking of the friendliness of the judiciary, which is one of the criteria under the CIR principles, Malaysian courts are known to be generally adopting a narrow interpretation of public policy, and we all know that public policy is the most generally used ground for when you file an application to set aside the award, right? So, and actually, when I was reviewing the cases, to give you a few examples today, there was a Russian case, Russia-related case, open-type joint stock company Efirne. So the case was before one of the Malaysian courts, and it actually was the matter where the Malaysian court explicitly mentioned that the public policy shall be narrowly interpreted in Malaysia. And in particular, and I would quote, the High Court stated that to fall within the public policy ground, the defendant would have to show that enforcement would be, and I quote, wholly offensive to the ordinary, reasonable, and fully informed members of the public, end quote. So a party wishing to invoke the public policy exception has to overcome this high threshold in Malaysia. Just very briefly, a couple of sentences on Indonesia, because Indonesia joined as a member state. The arbitration law in Indonesia is enforced since 1999. But a couple of years ago, in 2003, there was also an important change introduced by the arbitration community in Indonesia. Supreme Court enacted Regulation Number 3, 2023, on the procedure of appointment of arbitrators by the court, challenge rights, examination of enforcement applications, and arbitral award annulment. And this regulation, the main goal of this regulation is also to encourage international disputes and to promote Indonesia as a seat of arbitration.
So, Tatiana, you were talking about the plus here in the BRICS. So, and when I was actually, establishing a BRICS plus arbitration mechanism, in my point of view, is a challenge. Of course, I think in all the countries' points of view is a challenge, because it's a good thing to try. Of course, it would be beneficial to the countries, to the bloc, to the group. But I was researching the disputes in the main international arbitration institutions. So if you go, for example, for ICC, Brazil is the second one in number of parties with arbitrations in ICC. So if you go to others like LCIA, the Hong Kong that you've mentioned, so the BRICS parties, they are mostly in the top 5 seats arbitration institutions who have been established a long time ago. ICC in 1919, for example, LCIA in 1895. So they bring, of course, a tradition in arbitration, the best practice of arbitration. So that's one of the challenges we have to face, especially when we're talking about private parties, of course. If public parties, that will be easier to establish a joint mechanism, but private parties, it would be hard to convince them to go. I don't know. It will of course rely on the counselors and the lawyers to advise them in the best way to proceed, the best clause to use. At the end of the day, we're talking about the arbitration clause here. So
Certainly. Certainly, Daniel, just to add up something to what you were saying, I mean, speaking of cooperation between arbitral institutions, which is already happening under the BRICS umbrella, right? The institutions from Southeast Asia, they also have, most of them, they have extensive network with international institutions all over the world. There is, bilateral agreements which are being signed every year, and there are all sorts of innovations being suggested on how the institutions can cooperate. Just one of the interesting examples, which I personally witnessed in my times of work in Malaysia, when the Belt and Road Initiative was being developed, certain institutions from China, for instance, were interested to partner with Malaysian arbitral institutions, including the Asian International Arbitration Center. And one of the points of collaboration was an exchange of arbitration experience by cross-impanelment of arbitrators. So a certain group of Malaysian arbitrators was impaneled by Chinese arbitral institutions and vice versa. So just one of the examples of how on the level of institutional cooperation, further steps can be made.
But that's a very good example. For example, as I know, when an arbitration dispute, and we're going now jumping to China, but when an arbitration dispute goes to China, is against a Chinese party, like, for example, Brazilians, they prefer an institution like the Singapore International Arbitration Center because they feel it's neutral, it's close to China, but people there have, of course, good English, for example, and it would be easier than facing a Chinese party in China mainlands, for example. But of course, that's changing right now, Terrence, because China is opening itself a lot in the past years. And, the first time, and I can disclose that you contact me, you were representing a Chinese arbitration center, Guangzhou, and you were looking for partners in the BRICS. So that the law, the draft bill of the Arbitration Act is opening, of course, is putting the Arbitration Act in China in the best world international practices. So what can you tell us about how do you feel the Chinese, and of course you will bring this experience from the UK, which is the preferred arbitration seat, international arbitration seat in the world. So what amazed me in the UK is that 33% of the parties in the judiciary are international. So the courts being used to international parties, to dealing with international parties in the UK, for example, is a major feature for London being one of the preferred seats in the world. So if I'm going to talk about Brazil here, I don't think the Brazilian judiciary is used to it, to deal with international parties, for example, just in certain cases like adoption, divorce, or something like that, but not of course in arbitration, setting aside and awards and stuff. So Terrence, what can you tell us about the Chinas, like mainland China, Hong Kong, and of course whatever you can tell about us about the friendliness in China?
All right, sure. So speaking about China, right? I mean China, I would say the Chinese, arbitration environment is generally, considered arbitration friendly. So actually back in 2016, I was in a conference, which is the IBA International Bar Association Arbitration Day in Shanghai. Most of the commentators, most of the question on the floor is China considered friendly jurisdiction for enforcement? So actually we can reflect now, and 2025, I think the answer is yes. Yep. So we have to understand the China unique reporting mechanism. So first of all, the China reporting mechanism is some of that. So if you enforce arbitral award in China, if the intermediate people court refuse to recognize or enforce the award, then this must be reported to the higher people court in the region. And if the highest people court upholds the intermediate people's court decision, this too must be reported to the Supreme Court. So in essence, no court can refuse the recognition or enforcement of an award without the Supreme Court's review, which actually has a threshold of setting off arbitral award in China. So when we talk about enforcement and arbitral awards for foreign arbitral awards, so Chinese court have a quite high rate of recognizing and enforcement of foreign arbitral awards. So when we're speaking about statistics, is about so the validity of the foreign-related arbitration agreements by Chinese court is about 80%, and the rate of revocation application for the foreign arbitral awards by mainland arbitration institution is only about 2%, which is quite low in the world as well. So the second thing I want to talk about, the history about the Chinese arbitration is back in. So we have the arbitration law back in 1995. Since then, the Chinese has been developing ADR a lot. So as mentioned by AJ, I think China and India, we do share the similarities about there's quite a lot of backlogs in the courts. So right now, in terms of judiciary level, in terms of the government level, in terms of the court, they are pushing ADR instead of like going to the court, because ADR is still, a preference, and it's more preferred by the respondent and claimant, as it's more fast and efficient. And when we talk about the government level as well, so the Chinese government has formulated relevant policies and plans to provide direction and support for the development of arbitration. So, for instance, the Central Commission for the Advancing the Rule of Law issued the pilot program for the construction of the International Commercial Arbitration Center. So the designating with big cities like Beijing, Shanghai, Guangzhou, and Shenzhen, and also Hainan provinces as the pilot regions for the construction for international commercial arbitration centers. So what it means by the international commercial arbitration centers, so it's quite different from China and other jurisdictions in the world, especially in UK. So in China, we do know that there's quite a lot of panels of pool of arbitrators they have to choose from the panel, from the pool itself. So, but from the pilot one, we can actually adhere the ICC rule that you can actually having to choose. You have the autonomous to choose the arbitrator outside the pool. Mainly, you can choose wherever you think is suitable to sit as an arbitrator, which is adhere to the ICC rule as well. So in terms of the judicial level, so the judicial level review and support the judicial departments in China, they play a very crucial role in supporting the arbitration for conducting judicial reviews, for arbitral awards, and also provide legal guidance for example, as a legal practitioner, if we are representing the claimant, it's very easy for us to get an injunction from the court to stop the respondent of siphoning the funds or even the moving the assets. So we can see the China now is, I would say, it's very arbitration friendly, and of course there's room for development and growing as well. One of the main thing about criticizing about China is always about the neutrality, because one of the key things about international arbitration is to choose your own arbitration. But aside from the 5 major cities I just mentioned, is right now we're still trying to progress to become more internationalized. By selecting Chinese arbitrators, I think there's always a fear from the committee or from the international business agreement or respondent. There might be some kind of biasness. So what effort the arbitration institution is doing right now for other cities, apart from the 5 pilot cities, there are so they are trying to expanding their pool of arbitrators. So that's what Tatiana has mentioned. So even like the arbitration institution in China, they are reaching out to Malaysia, to Thailand, to Brazil, to my dear friend Daniel, and to Russia as well, to actually expand the pool of arbitrators to become more international and to eliminate the fear of biasness. And you have the choice, you have the right to choose your own your arbitrator from your home country, or you can select the arbitrators from a third country. So I would say the China arbitration has a long way to go, but it's growing quite fearsome nowadays. Especially we have the apart from mainland China, we talk about the whole region as a whole. So we have the Hong Kong. So HKIC has always been a pivotal role in the whole Asia, or even like the South Asia, the Asia Pacific region as a most preferred arbitration seat. Yeah. Thank you.
Thank you, Terrence. And you're talking about enforcement of arbitration awards. And, in Brazil, the awards are enforced by our Superior Court of Justice. So foreign awards are enforced by, recognized and, of course, enforced by these courts. And I was researching the whole BRICS plus countries there. And China, I found some awards being enforced, trying to be enforced here in Brazil. And what what surprised me actually was that these arbitrations, they took place in China, in institutions like CIETAC. I thought it would be like an ICC. Of course, there were some, but I didn't find any arbitration award trying to be enforced from Russia, like from a Russian party. I mainly found like adoption, divorce, and they're also in India. I didn't find any foreign arbitration award trying to be forced in Brazil. Of course, this might mean that the parties are complying and are paying their bills, but but other than that, China, I found actually, because a lot of Chinese companies are also established in Brazil, so that might make some sense in that way. So just changing a little bit the order here, Yuri, you talked to us about the sanctions, and just so you have an idea, I've went to arbitration conference here in Brazil, that the sanctions are a topic. Russia is in the spotlight Russian arbitration in the spotlight when it comes to sanctions, and of course it's a challenge that all international arbitrations will and might arbitrators might face. So, when it comes to sanction, will the Russian anti-sanction laws prevail over arbitration clauses? What's your feeling about that?
Actually, this is a very, popular topic right now in the Russian arbitration community, and the short answer is yes. This all anti-sanction local Russian legislation will prevail over the arbitration clauses. So this is very important to know when you're dealing with the Russian party today, because the most funny thing is that a sanctioned party, or I would say a Russian party, is entitled to start litigation in Russia ignoring an arbitration clause. And moreover, a Russian party may ask Russian court to issue an anti-arbitration injunction, preventing the other party, for example, Western party or foreign party, to continue or to start an arbitration with a seat in states imposing sanctions against Russians. So there is an idea that the Russian courts just believe that sanctions impede access to justice outside of Russia, both to arbitration, both to commercial courts. In fact, it is almost right. For example, right now it is very difficult to pay arbitration fees to certain arbitration institutions located outside of Russia, either to ICC, to Stockholm Chamber of Commerce, and so on and so forth. Moreover, there is also a legislation in Russia which allows to consider all disputes involving sanctions against Russian companies and individuals in Russia, and irrespective of all arbitration clauses, or, for example, forum selection clauses. And I would say that the Russian Supreme Court has rendered a couple of quite important cases involved in this, and I'll just maybe briefly report on this. First of all was case in Star Logistic against Neighbors Drilling. So in that case, the Russian Supreme Court confirmed that the arbitration clause in that particular dispute, it was ICC clause, shall not be enforceable where one of the parties was designated by OFAC. So this is the United States Department of Office of Foreign Assets Control. And the second, it was very popular and well-known case in Russia. It was case Uraltransmash versus Polish company PESA. It was heard by the Russian Supreme Court in December 2021. In that case, the Russian Supreme Court confirmed that the mere fact of imposing restrictive measures against a Russian person involved in the dispute in international commercial arbitration, which is outside Russia, or we will sit outside of Russia, is assumed to be sufficient to establish that there is a restriction on access to justice for this person. Therefore, sanctioned Russian party may obtain, for example, an anti-arbitration injunction when an arbitration is seated in the foreign jurisdiction that imposes sanction on that party, and this sanctioned party is not required to establish that the sanction imposed or actually impeded its ability to participate in arbitration. Therefore, this is probably one of the challenges which Russian arbitration legislation is facing, and therefore I was just, was not too optimistic when calling Russian arbitration-friendly jurisdiction right now. But hopefully, this whole attitude may change when the sanction against Russian entities and Russian companies will disappear one day.
No, I'm pretty sure this is just a moment, and Russia is when we talk about companies, Russia is a huge market. So being outside Russia, talking about money, it's not a good deal for companies, for example. But so I think this will change soon, and not only I think, but I do hope that happens, because Russia is a lovely country. So AJ, you talk about lots of amendments in the Indian Arbitration Act. Could you highlight some good changes, and of course other changes that might not have worked very well, or some specificities about the Indian Arbitration and Conciliation Act, if I'm not mistaken? That's the name. So please, AJ, enlighten us about the status in the Indian Arbitration Act.
Daniel, as you know, we had a new act in 1996. The 1996 Act was based on the then gold standard, which is the UNCITRAL model law. Prior to the 1996 Act, we had three legislations relating to arbitration in India. We had the Arbitration Act of 1940, and then we had two legislations to give effect to the New York Convention and the 1928 Geneva Convention. So the 1996 Act was a consolidating and a modernizing act, which not only dealt with arbitration, but it also dealt with conciliation. So from 1996 until 2015, for a very, very long time, there were no amendments to the Act at all. And in that interim period, the working of the Act brought to the fore a lot of deficiencies in the statute, in the practice of arbitration, and also in the manner in which the courts actually interpreted these various provisions of the arbitration statute. So the 2015 amendments, to a very large extent, I believe, were a game changer when it came to, if I would, for want of a better word, upgrading the arbitration ecosystem in India. The 2015 amendments were an opportunity to fix a lot of abhorrent decisions which emanated from the Supreme Court and the High Court, which were arbitration unfriendly. And in a lot of decisions which have gone to the Supreme Court was of the view that it was beyond the Supreme Court to fix these ills afflicting arbitration, and any ills, if they need to be fixed, need to be done not by statutory interpretation by the judiciary, but by amending the law itself. So 2015 amendments brought a sea change in the manner in which arbitrations are conducted and how arbitrations were perceived by the international community in India. So if you would ask me what are the major changes which are brought about by the 2015 amendments, I would say first major amendment was fixing all the bad decisions which came out of the courts in India. And one major statutory amendment was to ensure that the involvement of the courts in the arbitration process was to support the process and not to intervene. Support and not intervention was one of the guiding principles which we saw coming through with a lot of amendments in the Arbitration Act. In 2015, the public policy ground of challenging arbitration awards was actually defined for the first time. I believe not too many jurisdictions in the world, the word public policy has been defined to a certain extent. So 2015 amendments, the amendments have talked about what constitutes violation of public policy. And I emphasize this because one of the most prominent grounds on which awards were being challenged in India was that the award was against the grounds of public policy. And they've been, over the years from 1996 until 2015, the courts were very liberal in interpreting what constitutes violation of public policy. So there was an urgent need to rein in this unruly horse that you call public policy. And that was done with the 2015 amendments. Another big game changer which was introduced by the 2015 amendments were the fact that this issue of conflict of interest when it comes to appointment of arbitrators was clarified. I believe the Indian statute is the first statute in the world which has, to a large extent, incorporated two schedules into the Arbitration Act, which are based on the red list and the orange list of the IBA guidelines on conflict of interest. So prior to the introduction of these IBA guidelines in a modified form, notions of what constituted conflict of interest were very hazy in India. So courtesy these amendments, now there is a great deal of clarity as to what constitutes conflict of interest when it comes to appointment of arbitrators. Thirdly, I would say these amendments have also brought into a very, very important change in so far as promoting institutional arbitration is concerned. As you might be aware, in excess of 80% of arbitrations in India are ad hoc arbitrations. So institutional arbitration is not very popular in India. And in an ad hoc arbitration, what happens is when two parties or the multi-parties are unable to appoint an arbitrator, the appointment of the arbitrator goes to a court of law, the local jurisdictional court. So what the 2019 amendments did is that it said that now you don't have to go to a court of law for appointment of an arbitrator. We are going to establish the Arbitration Council of India, which will be a body to accredit arbitral institutions in India. And then these accredited arbitral institutions in turn will take upon the responsibility of appointing arbitrators, doing the conflict of interest check and conflict of interest audit, and dealing also with challenges to the appointment of arbitrators. So this was another big change which was introduced by the amendments in 2019 and then modified further in 2021. But I must emphasize that the Arbitration Council of India is yet to be established. The government of India is in the process of establishing the Arbitration Council of India. As and when that body is established, this process of going to a court of law for appointing an arbitrator in the ad hoc arbitration process will be history. And what this will do is that it will do two things. One is reduce the burden on the courts, the backlog. You don't have to go to a court. You don't have to wait in the queue for 3 months, 6 months, 1 year for in an ad hoc arbitration for the court to appoint an arbitrator. You can naturally go to one of these accredited arbitral institutions, and the institution will do conduct the process of appointing an arbitrator in an expedited manner. So I think this is again one big change which has been introduced by the amendments. Immunity to arbitrators is another concept.
Sorry to interrupt you, but
Yes.
you're talking about this Arbitration Council of India, and that's a feature that for a foreign arbitrator, it surprises us when we're looking at the arbitration acts of another country, because but as I understand what you're saying here, and the foreign arbitrators, we don't know that there was a necessity because of the amount of ad hoc arbitration and not institutional arbitration. And that's exactly, just to compare and for you to continue your speech, and that's exactly the opposite in Brazil. In Brazil, the majority of arbitrations are institutional. I would say something like the 80%. So that's why we don't need, for example, an arbitration council in our arbitration act. So it was very interesting what you said. So please continue.
And Daniel, if I may add, one of the biggest problems with arbitration in India is the prevalence of ad hoc arbitration. And ad hoc arbitration is, it's like the Wild West when it comes to arbitration. You are, the parties are typically at the mercy of the tribunal. There's an utter lack of checks and balances in the ad hoc arbitration process in India. Removal of an arbitrator is extremely difficult on grounds of inefficiency. You can remove an arbitrator on the grounds of conflict of interest, but it's extremely difficult removing an arbitrator. And this is one of the reasons why the judiciary has also started promoting the concept of institutional arbitration. The judiciary itself has set up a lot of court-annexed arbitration centers. The government has also been promoting institutional arbitration. In fact, it's interesting to note that the Prime Minister himself has taken upon the task of promoting the concept of institutional arbitration in India. I quote from a recent speech of his, where he said that one of the foremost priorities of my government is to create an institutional mechanism for resolving disputes in India. So that's how seriously the government is actually looking at promoting the institutional mechanism of arbitration in India, because people don't trust the ad hoc arbitration process. But the problem now again in India is that institutions are there. It's not that there are no institutions in India. You'll be surprised to know that at last count, I counted more than 50 arbitral institutions in India. But the problem is the quality of these institutions. And that is why you need something like the Arbitration Council of India, which is going to accredit and grade these arbitral institutions. Because right now, as it stands, it's a laissez-faire policy when it comes to establishing an arbitration center. Any Tom, Dick, and Harry can pretty much set up an arbitration center. So it's very important in a country like India to have norms, as to how do people know what is a good arbitration center. You might say that market forces might play their role in promoting good institutions, but many a times people are taken unawares by the reputation of or the lack of reputation of institutions. So I think in the Indian context, the Arbitration Council of India, we're all hoping and praying that the council is constituted very soon, and that would usher in a big change when it comes to kind of promoting the cause and popularity of institutional arbitration in India. Again, what are the other amendments which modernizing elements of these recent amendments? I would say one is immunity to arbitrators. There was no concept of immunity to arbitrators under the 1996 Arbitration Act. Now there's a concept of arbitrators' immunity introduced. Confidentiality. We had a very circuitous common law route of implying confidentiality in arbitrations in India, by virtue of India being part of the the Indian laws being part of the common law system. But there was no express obligation of confidentiality, and now that has been introduced, and it has been introduced only not with respect to parties in the tribunal, but also with respect to the institutions which are involved in arbitrations in India. So I think these are some very, very important modernizing, and I would say even harmonizing elements which have been introduced into the Indian arbitration regime, which were hitherto not there in the Indian arbitration ecosystem.
Very good, AJ. India has a rich experience to share when it comes to amendments. For example, to amend the Arbitration Act in Brazil, there is always a huge discussion because we have strong arbitrators institutions such as the Chartered Institute of Arbitrators Brazil branch, and of course the Brazilian Arbitration Commission, and we only change, modify, or amend, of course, the Arbitration Act when there's huge discussion beforehand, because we sense here in Brazil that any change may be catastrophic. For example, there's current a motion in the Supreme Court. One political party asked the Supreme Court to establish the criteria of the duty to disclose, of the arbitrator's duty to disclose, and not to consider the IBA conflict of interest guidelines, which is, for arbitrators who actually are practicing with, that's completely crazy, So that's it. So we have currently more than 160 draft bills in Brazil trying to modify our Arbitration Act, but of course, 99% of them are completely nonsense and not going to pass, So, and some of them, for example, try to expand the arbitrability in Brazil. For example, arbitration to tax law, which is not allowed yet, but of course, maybe in the future it will be. In 2015, we had an amendment in Brazil that allowed expressly arbitration with the public administration, and that's growing a lot in Brazil. Arbitration with the public administration, which I don't think, for example, in China is not allowed in terms of arbitrability. Of course, Terrence, correct me here if I'm mistaken. But let's jump to the next question. So, Tatiana, you are based in Russia, so of course you know all about Russian arbitration, but you are very international. And AJ said one thing that caught my attention, and said that ad hoc arbitration is mostly like the Wild West. There's a good paper about written by Christopher DeHozo. He's a professor at Kansas University, and he compares international arbitration with a book called The Not So Wild West, because some people say that international arbitration is actually lawless. The title of the paper is arbitration lawless? That's the title of the paper. And some people say that international arbitration is lawless. And he says, even the Wild West wasn't that lawless. It had some rules. So that's a good book to have in mind, the Not So Wild West. So this paper is actually brilliant. So I recommend it to you. And of course, AJ was the meaning that the parties establish the rules in the pro. So it's kind of insecurity arises when that comes up. And do you want to add something, AJ?
Yeah, Daniel, with respect to which is better, ad hoc or institutional arbitration, there's a quotation which I very commonly use in most of my presentations. And it takes inspiration from a book, We the Nation, written by one of India's leading commercial lawyers, the late Nani Palkiwala. So here's how I paraphrased it in my own words. This is ad hoc versus institutional arbitration in the Indian context. So here goes, I quote, ad hoc arbitration in India is like a Rolls Royce of 1920s vintage. Stately, because it's dominated by retired judges. High fuel consumption, because the arbitrator's fees are based on the number of sittings and not on an ad valorem basis or on the daily rate. And it takes almost an eternity for completion. Whereas, on the other hand, institutional arbitration could be likened to a shiny new Honda Accord. It will take you to the same destination with greater speed, higher efficiency, and most importantly, in the Indian context, dramatically less fuel consumption, unquote.
Perfect. Thanks, AJ. So coming back to the plus here, Tatiana, which of course they interests us a lot. So are the BRICS plus countries, the Southeast Asia countries, actually involved in international trade in commerce with the basic BRICS countries? And do you see any disputes arising? So because when we talk about arbitration in abstract with the BRICS, so we don't actually know which business are being done and made between the countries at the end of the day. But so what's your sense about that? Is the commerce ongoing between the BRICS countries and the plus? And do you see any disputes arising from that?
Thank you, Daniel. Before I answer your question, if I may, just a very quick comment on institutional versus ad hoc, because what Ajay was sharing just now, it's actually quite similar to the situation we had in Russia here a number of years ago. And one of the major problems here was the number of pocket arbitral institutions, which were in existence here back in 2014-15. And the government here also decided to address this issue. And there was also a commission similar to what Ajay was describing. So there was actually, there were a number of amendments to the law on arbitration which were enacted. And in order to administer certain types of disputes in Russia, an institution must be, let's call it, to be licensed here in Russia. And there are not only domestic arbitral institutions which are now in existence here, but also a couple of foreign institutions which also received licenses here in Russia, for instance, HKIC. Now moving on to the investments between BRICS countries, members of the BRICS alliance, and certain Southeast Asian countries. So again, in preparation for today's discussion, I looked through the investment flows between a number of countries. I cannot certainly conclude that the scope of investments is growing, but it is consistent, certainly. And that some numbers are quite impressive. So for instance, speaking of FDI flows from Russia to Malaysia, in 2023 it was $619 million US dollars. Back from Malaysia to Russia, 2.49 billion, also in 2023. China to Malaysia, 6.4 billion in 2024. Russia to Vietnam, according to the statistics in January 2025, 995 million US dollars. A couple of other examples: Thailand, exports from Thailand to Russia in 2024, 882 million US dollars. Brazil to Vietnam, 3.85 million in 2024. Brazil to Thailand, export, 10.1 million US dollars in 2024. So certainly there is international trade, there are international transactions. And speaking of the economic sectors where these investments are flowing, for instance, between Russia and Malaysia, mostly oil and gas, energy and agricultural sectors, also some digital projects and projects in IT and pharmaceuticals. China to Malaysia, manufacturing, infrastructure, energy, digital technology, cars and vehicles. Russia and Vietnam, also energy, high-tech fields, oil and gas, natural resource extraction, nuclear power, and atomic energy. Brazil and Malaysia, semiconductors, energy, trade, and agricultural products. Brazil and Thailand, agriculture. Brazil, Vietnam, agriculture, food, and technology sectors. So this is what's happening between members of BRICS and certain Southeast Asian countries. But speaking of the disputes which are already in existence, and for instance, it also ties back with the experience of arbitrators based in Southeast Asia, for instance. The absolute majority of disputes, they're construction disputes, simply because of how quickly the region is developing, and it's explicitly seen from the statistics, annual statistics released by arbitral institutions based in Southeast Asia. For instance, if we look at the recently published 2023 annual report of the Asian International Arbitration Center, 59% of disputes administered by the AIC, they are construction disputes. Second most popular type of disputes is shareholders disputes and services contracts, general commercial, with some IP disputes. So yeah, certainly, again, there are flows. Experience is there in construction, in general commercial, international trade disputes. The other interesting question would be, what if there is a dispute, an investor-state dispute, which may arise based on the existing BITs, for instance. And also, in the interest of time, I won't be mentioning everything, but for instance, there is a BIT between India as a member state of BRICS and Thailand, and under this BIT there are a couple of options agreed by the parties. So one of them is either an exit mechanism or an ad hoc, and the second one is an ad hoc arbitration. Yes, so this is the general overview of the type of disputes and mechanisms which are in place at the moment.
But Tatiana, Daniel, with your permission, I'd like to just add something to what Tatiana said. India, I must say, has not signed nor ratified the Exit Convention. The government of India is still very, very suspicious of the whole Exit framework. And talking about BIT arbitrations and BITs in particular, although that's not an area of my specialization or practice, I must say that India, perhaps like Brazil and South Africa, has taken the step to rescind or terminate a lot of its bilateral investment treaties. I just asked a friend of mine who works for the government to give me a list of existing BITs with BRICS countries, and he told me that Brazil, there's a BIT signed but not in force as yet. China, yes, there is a BIT. South Africa, no treaty. Russia, terminated. Negotiations ongoing with the Russians on a BIT. Egypt, no, there is no BIT. Ethiopia, no BIT. Indonesia, terminated. Iran, terminated. UAE, recently, India and the UAE has signed a bilateral investment treaty arbitration. So I think India is having a very strong relook at the whole investment treaty, investment dispute settlement process, because I think there being a lot of misgivings in the Indian context. Initially, especially 10 years ago when we had the White Industries case, which was a wake-up call to a lot of people in India, especially the judiciary and members of the legal profession, who hitherto didn't know what the BIT was, didn't know what the practical effects of losing a bilateral investment treaty were. So all of that came home with the White Industries versus Republic of India case, which was about 10 years ago. So I think now there's a big rethink. But the thing is that the thought process is that not to throw the baby out with the bathwater, but to continue the process, but to look at the process in more in more favorable terms from the perspective of an investment recipient country.
Thank you for the clarification, Ajay. I mean, apparently the landscape is changing, constantly changing and evolving, especially after some fundamental cases in the investor-state arbitration arena. But just a quick note, if I may. I think it's also important to know to have in mind when we discuss potential investor-state disputes involving Southeast Asian countries. The ASEAN countries, they also have certain experience and certain understanding of how investor-state disputes need to be resolved because they have the ASEAN Treaty. And within the ASEAN Treaty, there is also a separate special mechanism for the resolution of such disputes. To my knowledge, there were no disputes arising out of this agreement yet, but certainly there are some lessons learned when it comes to the negotiating of these provisions of the treaty itself, and possibly some disputes, they were at their initial stages and they didn't materialize. But we learn about these things a bit later, right? So yeah, there is also knowledge and understanding of investor-state arbitration in that part of the world, which also can be taken into account when harmonizing the mechanisms.
Tatiana, just one practical observation here. When I was flying to Moscow last year, I was amazed about the amount of Brazilians that were flying actually to Bangkok in Thailand, and that they had business there. So lots of people. Of course, Bangkok is a hub. You go to Bangkok to go to other parts of Asia. But I talked to some of them, and they had big business there in Thailand, and so it's a relevant market in Brazil, and of course in agriculture especially, they sell a lot of commodities to South East Asian countries. So that's relevant to us. For example, Brazil went to Russia to get the fertilizers. We rely on Russia for our agriculture, so we always buying fertilizers from Russia. So it's a big market for us. So it's a very, very important commercial partners to Brazil. And so jumping now to China again. So Terrence, I know you study and you see in practice one of the cutting edge topics that we're discussing currently in arbitration, and of course in society in general, which is the use of artificial intelligence. So what can you tell us about the benefits, about what you've seen, especially in the Chinese market and in the arbitration proceedings, and about the benefits for the use of AI to arbitrators? So in your experience, what can you tell us about it, please?
Okay, Daniel. I mean, AI is something we talk about. It's most discussed in the world. We talk about, in China, we do have DeepSeek. We have, Baidu, one of the pioneer of AI. And in the West, in US, we have the ChatGPT, we have the OpenAI. So the use of AI has been, circulating the legal sector for quite some years. It's not only about the arbitration. We talk about the whole legal industry as well. As a legal practitioner, there's software, there's like apps to help the lawyers or even the judges to perform some of their works. So we are actually in the era which is quite reshaping the very fabric of society and the economics. I would say the legal and dispute resolution landscape are undergoing quite a big shift. So when we talk about the integration and AI into the arbitration project, it's just I don't think it's just a trend. It's kind of like a revolutionary force that has the potential to redefine the way we resolve the dispute and make it more efficient, fair, and accessible. So before delving into specific of China, I think it's crucial for us to talk about the global landscape of AI arbitration. So across the world, I mean, some of the arbitration institutions and legal practitioners are at the forefront of embracing the AI technologies like what just I mentioned, to streamline the processes, to reduce the cost, and also improve the quality of dispute resolution. I mean, as you use AI in document review in large scale, like some of the commercial dispute. Some of the volumes of documents can be large, often running into like maybe 1,000 or even 100,000 pages. So traditional manual review is not only labor, I would say it's more intensive time consuming, but also prone to human errors such as fatigue and you will induce oversight. So the other hand, we talk about is like predictive analytics is another area where the AI is making quite a significant impact globally. So by analyzing the vast amount of historical arbitration data, including case outcomes, legal arguments, and some expert opinions. So AI actually can generate predictive models that offer quite valuable insights into the likely outcomes for the future dispute. So when we're back in China, I knew one of the panel I sit for, the Guangdong Arbitration Commission, is actually, I would say, is one of the leading arbitration institution in terms of application of AI. So one of the things we've been using for the AI is for the case assessment tool, which is to analyze the facts of the case and the relevant like legal provisions and the past similar case to provide an initial assessment for the case strength and weaknesses. So by doing this, we can actually help the parties to decide whether to pursue the arbitration, to negotiate settlement, or explore other ADRs methods. And for the Guangdong Arbitration Institution, this too can actually assist in the case to ensuring the case are assigned to the most appropriate arbitrators and the resources are allocated efficiently. So what the Guangdong Arbitration Institution is doing is actually they have the pool of arbitrators and they have an AI to analyze the performance of each case. So by having this kind of data, it will help the party to assess, whether they want to when they want to appoint a specific arbitrator to have the AI to help them to determine which arbitrator is suitable for their cases. And when we talk about so when we move on to arbitration hearing stages, AI is being used for real-time language translation and transcription, especially in China. Sometimes when we talk about in international arbitration, English is always the language medium. But in China itself, we do have quite a lot of dialects, which poses some big problem when we talk about, especially in Guangdong area, in the south of China and the north of China, they do have different dialects. So the AI is being trained to understand the dialect as well. So actually, it will break down the language barrier, so and bring a smooth connection between the parties, arbitrators and witnesses. And we do have the real-time transcription system, which can generate quite accurate written records for the proceeding as well, which is reducing the needs for manual notes and improving the efficiency of hearing process. So, wow, so AI in the Chinese arbitrations, when we talk, is quite good promises, but the challenges and consideration is still there. And we do understand one of the main thing and the complex legal issues is the data privacy and security are one of the major concerns. So in arbitrations, parties often share sensitive and confidential information, including trade secret, financial data, and personal details. The use of AI might establish a robust data protection laws and regulations, which is similar to the GDPR in European Union, to ensure the data processed by the AI system is handled, I would say, securely and in compliance with the relevant laws and regulations. What another challenge is, I think this is often discussed as well, is actually the potential bias in the AI algorithms. The AI system are trained on historical data, which basically contain inherent bias. If the historic arbitration data used to train an AI algorithm is biased towards a certain types of parties, industry or legal arguments, the algorithm may be propagated this biasness. But as a whole, in my perspective, despite these challenges, AI is much of the future not only in China, but the world as well. With the right approach, I think we can harness the power of AI to create a more efficient accessible, and fair arbitration system. I think one of the key things for the future development would be in terms of standardizations. So most the arbitration institution in China, they're actually having a talk about how to standardize the arbitration rule in terms of using AI. So this will ensure the consistency and quality across like different arbitration proceedings. The other thing I would point out that I think the education and training are also essential. I mean, to provide to the arbitration practitioners, legal professionals, and parties, I mean, with the necessary knowledge and skills to effectively use the AI technologies in arbitrations. And so in my closing, I think the integration of AI into arbitration in China represents a significant opportunity to transform the whole dispute resolution landscape. While there are still challenges and consideration to navigate, I mean, such as the legal and regulatory uncertainties, and also some guidelines in terms of the guidance or ethics to the arbitrators. I mean, in the certain right approach or in the future, I think this can be easily overcome and shape a future where AI and arbitration work hand in hand to provide a more effective and just dispute resolution mechanism. Thank you.
Thank you, Terrence. And that's a curiosity to us Brazilians, because I say that Brazil is a language miracle, because we are a huge country with only one language, even though accents can be very different in the Northeast, in the South. So, but of course, if you speak Portuguese, you can go all around easily. And I know, for example, you talk about the dialects in China. India has, if I'm not mistaken, 2 official languages, but 22 different dialects. It might be more, I don't know, AJ. And I had the experience in Russia of the Tatar, and of course you have the Bashkir, I think so, other 2 languages, and it's strange because Tatar in Kazan, in the Republic of Tatarstan, people who speak Russian, they don't speak Tatar. And to me, to a Brazilian, was mostly like Portuguese and Spanish, you know. So if you can understand Spanish, if you speak Portuguese and so on, but it was not. So that's different to us, and maybe AI can be actually a very useful tool for that. And as in Brazil, we usually use AI for conflict check and tools like Jus Mundi. They have a good tool of conflict check, and of course for text mining, it's very useful, especially if you're applying to e-discovery. E-discovery is huge chunks of documents that you have to go through. So sometimes searching a document, it makes it makes easier to use AI. So it's a topic that we need to discuss the ethics about it. So there's so much to develop and to go on. But China, I think it's in the front of this application, that should say in that way. But moving back now to Russia and to my dear friend Yuri. Yuri, when we talk about arbitration, everything is born in the arbitration clause. So we talk that one of the most valuable lawyer skill is drafting a good dispute resolution clause. So you need to foresee which disputes might arise from that contract in order to draft a good dispute resolution clause. But of course, when we talk about Russia and sanctions, this is quite of a bigger challenge when drafting an arbitration clause. Is there any particular notes that you'd like to address when drafting arbitration clause where Russia, for example, will be the seat of the arbitration? Because, you know, for a foreign arbitrator and lawyer, if you receive a notification of an arbitration where the seat is in Russia, he will be surprised at the first moment, and probably he won't know what to do right away. Of course, they can contact your law firm right away, But other than that, you'll be surprised. Not like, oh, it's Paris, it's ICC, it's London, it's LCIA. That will be, of course, easier to deal with. But when in Russia, is there any particular issues that you would like to address, specifically about the arbitration clause?
Thank you very much. Definitely, Russia is not very popular place as a seat of arbitration. But I would say that if we're speaking about international arbitration, there are a few points which you have to know when you're dealing with a Russian company. For example, when it is a party to arbitration, or when you are drafting an arbitration clause involving a Russian party, or when the Russian company suggests Russia as a seat of arbitration. I would say that when you're dealing with a Russian company, please note that for Russian companies, it's very difficult to pay the arbitration fees, for example, for certain foreign arbitration institutions. Therefore, Russian companies suggest Russia as a seat of arbitration. And I would say that in many international contracts, cascade arbitration clauses are suggested. For example, when it is not possible to initiate an arbitration in one arbitration institute, then the parties have already chosen some other arbitration institution where the dispute could be suggested, or the dispute could be initiated. Of course, it is very important to be very much specific, and the Russians are usually suggested to use model clauses recommended by arbitral institutions in order to avoid an argument that the clause is incapable of not being performed. And it's quite interesting then if you will mention in the arbitration clause that the arbitral award will be final, and you put the Russia as a seat of arbitration, then your case will not be subject to setting aside before the Russian courts, which is good. If you do not want to go to the Russian courts and litigate there. One very interesting feature for arbitration involving Russian parties right now is that if you would like to have your award be enforced in Russia, you have to think very careful about the arbitrators, whose nationals they are, whether they are from unfriendly states or friendly states, in respect of how well known in the arbitration community will be the arbitrator which has to consider a case involving the Russian company. Why this is so? This is also goes from the practice of Russian courts. Last year, the Russian Supreme Court considered a very interesting and important case involving recognition and enforceability for an arbitral award in a case Thyssen against Novosibirsk Khlepoprodukt, and the fact that the Russian Supreme Court refused to recognize and enforce an arbitration award from an international arbitration institution based on the presumption that the arbitrators who considered this case were from unfriendly countries, and that's why they are lacking impartiality and objectivity. And in that particular case, the arbitrators who considered this case were from the UK, from Denmark, from Ukraine, and the Russian Supreme Court mentioned that, irrespective of the fact whether those arbitrations were challenged or not challenged, as long as there is no evidence to the contrary, the arbitrators from unfriendly states were presumed to be lacking of impartiality. That's why when you have a dispute, an international arbitration against, for example, Russian company, please take this into company if you believe that one day this arbitration award has to go to be enforced in Russia. That's probably.
Thanks a lot, Yuri. Spasiba. Yeah, it's a matter we should consider when, of course, when drafting the arbitration awards and the arbitration agreement. Sorry, and thanks for your enlightenment here on this matter. So I would like to thank you all very much for being here, for joining us. I know your time is valuable, and we are in different time zones, which it makes it even harder to be here. But thanks a lot, Tatiana, Yuri, AJ, Terrence. So please, now I will open the floor for your final remarks. And we should do this more often. I think we should share academically and of course in webinars, in conferences, our practices and unite ourselves so the BRICS countries go stronger and stronger. And of course, that crosses the dispute resolutions ways that we've been practicing and putting into practice. So please, Tatiana, your final remarks, and thanks a lot for joining and for being here.
Thank you, Daniel. Two key takeaways from my side. First is that it's not only the matters within the BRICS Plus alliance which are constantly evolving, but also the dispute resolution community and dispute resolution area itself is constantly evolving. So all of us should basically keep ourselves updated of what's happening almost on a daily basis. And secondly, dialogues like this one, even though we are having this discussion remotely, greatly help to promote understanding between practitioners from different jurisdictions. So cross-cultural exchanges are also very important, and for the understanding and for the general exposure for each of us. Thank you, Daniel.
Thank you, Tatiana. Thanks a lot. AJ, please, your final remarks.
Thank you, Daniel. Well, I'm reminded of the words of the present Chief Justice of the Supreme Court of Singapore, Sundaresh Menon, who at the ICA Congress held in Singapore a few years ago had said that this is the golden age of arbitration. And we, all of us out here, who practice arbitration are extraordinarily privileged to be part of this golden age of arbitration. So I can only but second your thoughts, Daniel, Tatiana, that these exchanges are extremely useful in this golden age, because arbitration is a truly international process. And it's extremely important to develop cross-cultural sensitivities, when you're looking at arbitration as a harmonized process of resolving disputes. So with those few words, I'd like to thank the Arbitration Channel, Daniel, Elizaveta, and Daniela for your kind invitation. Tatiana, Yuri, and Terrence, it's been a fantastic session. 2.5 hours, 2 hours have just flown by. And, it's been an extraordinarily privilege and an honor to be part of this discussion. And last but not the least, thank you to Fernand from the Arbitration Channel for putting all of this together on the technical front. Thank you.
Thank you, AJ. You're always brilliant. Thanks, my friend. And Terrence, please, your final remarks from New York, China, London, wherever you are, my friend.
Thank you, Daniel. Thank you for all the fellow panelists. It's been a great honor to be here with all the the professionals, the distinguished arbitrations practitioners in this channel, especially Arbitration Channel for hosting as well. I mean, I do agree with what Tatiana and AJ, of course, Daniel as well. I mean, arbitration is an international process, and we, as a community of arbitrators or practitioners, should stick together to exchange more about the recent developments. It's quite surprising what AJ has been mentioned today, because in India, India is quite a big development in India. I do have quite a lot of clients that in India, so definitely I have someone to look for in the future already. Especially Tatiana, I think I speak to you from WhatsApp. I do have a case we've been discussing before. So I'm looking forward to work with everyone in this panel. And of course, Daniel, you as well. You've always been a great friend and always think about me. And I hope to see you all in China in one day, if not New York or London. I'll be there. Thank you.
And Terrence, while I was in Russia last year, I saw many Chinese there in Russia. So like Russia and China, you are in very close relations. So Brazilian, I was the only Brazilian there, but Chinese, you were everywhere there. It's a good thing, a good partnership. So once again, thanks a lot. And Yuri, please, your final remarks. And thanks a lot, Yuri, for taking your time and for joining us. It was a true honor.
Oh, that's that's true honor for me to be a part of this discussion. Thank you very much, Daniel, for moderating. Thank you very much for the panel, for our co-panelists for this fruitful discussion. And I hope that the audience will enjoy our discussion. So I hope that I provided some new information for you and for the audience about Russian and Russian arbitration. Hope that will be useful for you if we will be dealing with the Russian related matters or Russian parties. And I hope to see you all during international arbitration conferences throughout the world. And please feel free to reach me and Tatiana if you are in Moscow or have any problems in Russia or with respect to the Russian parties.
Thank you, Yuri. I truly hope I go to Moscow soon. But I'd like to finish our webinar here, thanking once again Lauro Parenti, the CEO of the channel, and of course my co-organizers, Russian very good friend Elizaveta Gromova and Daniela Demoro, who also helped a lot. So without you all, this conference wouldn't have happened. So thanks a lot and hope to see you all soon.